Okay, hello, everyone, and welcome to In Conversation session within the IRDR 13th Annual Conference, Risk Without Border. Thank you for attending today, and we are honored to have a special guest with us, Dr. Mykola Gnatovskyy, a judge at the European Court of Human Rights. And with us in the audience are members from IRDR, wider UCL community, and beyond academia. In this session, we will be talking about international law and how it addresses armed conflict and migration. This topic fits within the wider discussions of this annual conference on the definition of borders from multiple perspectives. And when we will be talking about borders in the context of this conversation, we'll be talking about borders between the states. For a quick introduction, Dr. Mykola Gnatovskyy has 25 years of experience as international law academic, practitioner, advisor to Ukrainian government. He served as a president, vice president, and a member of European Committee for the Prevention of Torture and Inhumane or Degrading Treatment or Punishment, or CPT, for over 10 years. And since 2022, Dr. Gnatovskyy has been the judge at the European Court of Human Rights appointed by Ukraine. Just for non-lawyers out here, European Court of Human Rights is an international court of the Council of Europe, which interprets European Convention on Human Rights, which is a different court from the court, which is the highest court of European Union, which sits in Luxembourg. Judge Gnatovskyy holds a PhD in international law from Institute of International Relations of Taras Shevchenko National University. So before taking a deep dive in our topic, would you mind starting with sharing how you got into international law, a bit about your background, what drew you to international law, and what keeps you motivated to keep going?
Well, thank you very much. And first of all, many thanks to you, Yulia, for the idea and for being here today talking to me. And I'm very grateful also to UCL for this invitation. I'm really delighted to be here amongst you. And it's a particular pleasure actually to be present at an interdisciplinary conference, not just another event among lawyers when we discuss the intricacies of the recent judgments and the case law, but to be able to speak to people who are interested in who work very much in the extremely important domains, and the topic of your conference, is certainly much more important, I would say, that law is such. Law has a certain function there, but issues you are discussing, they are far more important. So I'm very, very, very glad to be here. And turning to your question, well, I mean, international law is indeed my profession, and I became very interested in international law whilst already being a student of law. And I thought that this is a fascinating project of making our world better, a better place to live, so to say. Because ultimately, all these ideas that underlie international law, these are ideas how to achieve something for the humankind, starting from meeting the basic needs such as peace, security. Now, of course, nowadays one would immediately talk about environment because, well, it wasn't the case before. For centuries, people didn't even think it was a problem at all. They were taking everything for granted. But now certainly there is this consideration. There's the project of human rights, which is extremely familiar to me because this is how my professional life has evolved, and I'm basically concentrating there, but also humanizing certain things, bringing human dimension to things that are not so humane themselves, such as war, for example, and hence the whole project of the so-called international humanitarian law, the law of armed conflict. So these are matters which have always interested me, and I must say I have never been particularly excited about the perspective of becoming a prosperous lawyer who has plenty of money, who deals with with corporations, with some purely business interests. Because I think that's not the most direct way of actually earning money. You can earn money by actually producing something or directly trading. This is sort of a service function. You're a servant of the money. You're a servant of business, which is, I mean, totally legitimate and important and it's necessary, but not what interested me so much. So that's why I've always, life is about choices. So every time I was making a choice in favor of something that was just interesting, but perhaps less obvious in terms of having some direct result in terms of money. And this is how I first chose international law, preferred international law over, let's say, civil law, private law, commercial law. Then within international law, there's plenty of things you can do because international law is vast. It's enormous. It's like an ocean. You find anything there. And again, you find things which are very practical, which are also related to money and to industry, and they are super important. To trade, again, like the entire law of what is now known as the international trade law, the law of the World Trade Organization. These are fascinating things, but I was never interested in them. That's the thing. So I chose the topic of looking into European human rights law, how European law was evolving, also how European law, not in the sense of the European Union law, that's important, but rather the more global European project, the project of the Council of Europe, which emerged immediately after the Second World War, predominantly on human rights, but also on things like rule of law or democracy, things like this. And European Union, among others, but also, let's say, the Organization for Security and Cooperation in Europe, how those were influencing domestic legal systems, how we were all becoming sort of parts of the single sort of legal space in Europe. So that was my initial academic interest. I got then very interested in international humanitarian law, in the law of armed conflict, at the time when this appeared to be of no relevance to Ukraine whatsoever. And I'm very unhappy that it is so relevant now. I would have loved to keep it as far possible away from home, as far away from home as possible. But this is how it worked. So then there was more sort of emphasis on human rights, and I was very lucky to, as you mentioned, to join the European Committee for the Prevention of Torture. I simply submitted an application when there was a when there was a call for applications, because there's members elected in respect of various European countries, and there was this competition for basically the Ukraine needed to nominate 3 persons, and then it was for the Council of Europe to elect. And I did it once because I was interested in the topic academically. I never set foot in a prison, let's say, or a police station. Or psychiatric hospital, but I was academically interested. I published something about that, and I was unsuccessful the first time, and I was successful the second time, to my huge surprise. And that gave me very practical experience of actually, practicing human rights, working with people who are the bearers of those rights, and those people who have to put up with a lot of suffering for the reasons that could be sort of due to their own fault, or which could be purely, a whim of nature. If somebody has a mental disease, that's not the fault of this person at all, and this person suffers and is often treated in a way which further increases the suffering. Or the migrants. That's another huge category, and I think that many of you would be interested in that, and that might be one of our main topics today, the situation of foreigners who come to another country looking for a better life, but then they end up in detention. And their situation is one of the most desperate ones, among any category of detained persons. So that kind of thing, and being directly there, coming to their quarters, to prison cells, to these detention centers, to police cells, to psychiatric hospitals, working directly with them, talking confidentially to those people. And these are the powers that the European Committee for the Prevention of Torture has all over Europe. At that time, 47 countries in Europe, far beyond the European Union again. So that was well, that completely transformed me. I think professionally, I became much less of an academic, much more of a practitioner. And then yes, there was another vacancy coming up. There was a vacancy of a judge elected in respect of Ukraine for the European Court of Human Rights, and I again applied. And the procedure was tedious. There were three complete repetition. It was like everything went up to the very end. I was included in the final list of 3, and then this procedure was derailed for some reason, and then it started all over again, and then it happened the second time, and then it happened the third time. No one was elected. It's just we just had all these procedural issues and so on. But finally, I ended up in the final list of 3, and then the Parliamentary Assembly of the Council of Europe elected me, so I became this judge. In the meantime, just before election, you mentioned that I worked for the government. Just don't misunderstand. I never worked for the government in the sense that I've never been a civil servant. I never received salary from the government for being a civil servant, only as a university professor. But there was a very urgent practical need. Because, well, with the large-scale invasion of the Russian Federation into Ukraine which started on the 24th of February last year, for me, it was obvious that I would be useless in the military. Unfortunately, I do have a training as a military interpreter, but they didn't need one anyway. At that point. I offered my free services as an independent advisor to the foreign minister, and who happened to be a former colleague from International Law Department. So it was, I could do that. And it was kindly accepted. And then I had a project together with a UCL professor, Philip Sands. We had a project of a special tribunal for the crime of aggression against Ukraine. The project is still ongoing. I had to leave the project because I was elected to the court. But those were several months when I was very much involved there. So basically, this keeps me running. Sorry, it's a very long answer, but it's sort of a self-introduction as well. That's why I took the liberty of speak so long. But that's just to show, and these are all extremely interesting things. Well, this anti-torture work I was busy with was absolutely fascinating, and it was a part-time. Admittedly, it was a part-time job, even though being the president of that committee meant effectively full-time job. But formally, it was still part-time. My university had always been extremely tolerant to my side activities, so they really accommodated all my needs. And then and the judge is a full-time job, and then you are overwhelmed with lots of judicial work, which is also extremely interesting. So in that respect, I would say I'm extremely motivated to continue my work.
Perfect. Thank you so much for this excellent answer. A lot of things to follow up on. But what I've learned, the main point is just apply, everyone, to the jobs. And you might become a judge at the International Court at some point. At least that's what I will be doing after this presentation.
You absolutely should.
Sure. So, Judge, you were talking about armed conflict and international law. And when the European Convention on Human Rights was initially adopted in the 1950s, it was presumed that it will function in the peacetime, and it wouldn't necessarily protect human beings in the time of war. But we can now see that the court you're working at is dealing with a lot of cases that are connected pertaining to the armed conflict. Our regional human rights courts, like European Court of Human Rights, is the best place for this kind of cases. And do you predict any sort of changes in the court's approach to the cases associated with armed conflict?
Well, thank you very much for this question. I honestly, I think the European Court of Human Rights was set up to supervise the implementation of human rights in the post-war context. So it is related to war, genetically, but the idea was actually to prevent future wars by making sure that Europe is a continent which is basically run with full respect to human rights, whilst understanding the value of an individual. So basically, because if you value an individual, if you are serious about individual rights, you would not contemplate, aggression, a war of aggression. These are simply worlds apart because it's absolutely not your agenda. It just can't work like this. But this liberal understanding that it will be possible to keep everyone well behaved if you make sure that they assume all these human rights commitments, and then their democracy is functioning. They have regular elections. They have free speech. They have, their courts domestically function well. There's rule of law in the country. Those countries would never actually face the war. This liberal dream has unfortunately not come true, because now there is an elephant in the room. So I will try not to speak answering every question about Russia's war against Ukraine, but at the same time, both were parties to the European Convention of Human Rights. Both accepted the jurisdiction of the European Court of Human Rights. Both were member states of the Council of Europe, so accepting the obligations to maintain a democratic regime, to have regular free elections, to respect the rule of law, at least basics and so on. But that didn't help ultimately. So now the European Court of Human Rights is back to square one, or even before. So it's back to the situation which predated the creation of the court. And it has to make these rather hard choices how to react to that. The idea was that the court would be seized only in very exceptional cases, where there would be an issue with how a domestic government is treating their people, whether it is in accordance with the European Convention of Human Rights or not. Hence, there was the right of individual petition, the possibility for an individual to apply to the court, created and developed. With time, the barriers were just disappearing, because the European system started as a two-tier system. You first had to go through the Commission, and then exceptionally through the court. Interstate cases, when one state would complain about the systemic non-observance of human rights by another state, were highly exceptional. Well, of course, there was Ireland versus the United Kingdom. There was the Greek case. There were cases, but these are really unique cases, really exceptional. And it turned out at the end that the European Court of Human Rights in Europe is the only international court, is the only international body which has the right of individual application. You can directly go there and say that because of the war, my rights as the rights of an individual have been violated. And the court does have this jurisdiction. That's it. So the court has to adapt and respond, because saying, "Oh, sorry, we were created for peaceful times. Now, please, let us continue business as usual." The court is not in a position to say so, obviously. That's why the court has to adapt. So whether it was created for this or not, it now has to do this. And then, of course, you asked about changes that would be associated with armed conflict. Of course. The European Court of Human Rights, throughout decades, has been literally forced to engage with the situation of armed conflicts. It had to adopt some of the concepts that belonged exclusively to the law of armed conflict, to the so-called international humanitarian law, into the domain of human rights, because lawyers would know that these are considered to be separate legal regimes. They are considered to be independent of each other, applying at the same time, but independently of each other, if that is possible at all. But I don't think it's conceivable. But this is what so the theory would say about this. And the European Court certainly can only rule on whether a state has complied with its obligations under the European Convention of Human Rights or not. It cannot say that, oh yeah, maybe there was no convention issue. However, international humanitarian law was violated. I mean, the Inter-American Court tried things like this. They, as you know very well, they basically they had a very general clause in the American Convention, which allowed them to, on human rights, which allowed them to say that, for example, there was a human rights issue because Article 3, common to the 4 Geneva Conventions, has been violated in a given case. But even they slightly went back, so they weren't sure that they were doing, I think, they were doing the right thing, because they're not consistent. I mean, this approach has not been consistently maintained by them. But the European Court had to view the convention rights through the lens of international humanitarian law. So some concepts were initially some concepts were adopted from law of armed conflict without saying that these were concepts of the law of armed conflict. So anonymously, basically taking the 1949 Geneva Convention principles into European human rights, but not mentioning a single word, not saying a single word about the Geneva Conventions. But it was obvious that it was exactly it. I mean, you assessing, let's say, the proportionality of the in the use of armed force under the criteria that were developed for international humanitarian law, but saying no, it's actually human rights law. And this was these were the cases that the so-called Chechen cases, where the non-international armed conflict within the Russian Federation with Chechnya was the subject of these cases. And then gradually the court had to say that in fact there was international humanitarian law, and it had to be taken into account, and it had to be at least called by its name. So the court, even through some historical cases which were basically dealing with crimes of the past, for example, like the Latvian case, the Kononov versus Latvia, so, where there was an obvious war crime committed in 1940s during the Second World War, and then the person was subsequently convicted, and then the person was complaining that, why do you convict me? It wasn't a crime at that time. So the court had to look whether it was a crime, so it had to check, roughly I'm generalizing, but it had to check whether international law of armed conflict at that point was already criminalizing certain conduct, certain things which would certainly be considered as war crimes today. So gradually, these changes came, and one can, it's not even enough to have one lecture about this. You should have a proper university course, because there was quite a significant development. But ultimately, I don't think that everything has been answered. I believe that the European Court will have to further develop this line of its case law, and unfortunately, it has plenty of opportunities for doing so.
Perfect, thank you. I'll just follow up on something you already said about interstate applications. So as we understood, court mostly deals with human beings, individuals who apply to the court, but states can apply as well. And as you mentioned, historically, it wasn't such a common occurrence, but we see now Ukraine has 4 pending interstate applications. connected to the armed conflict that started in 2014. So how do you perceive this more frequent use of interstate applications, and what are the advantages for states to pursue those cases before European Court of Human Rights instead of, for example, International Court of Justice that deals specifically with states? So arguably that could be a more logical option for states.
Yes, thank you very much again. I think that's the most important thing that the European Court of Human Rights is faced with now. There are, at the moment, 14 pending interstate cases at the European Court of Human Rights. And there has been more, but Georgia versus Russia #2 has been finally completed, also with the compensation issue, so it's over. So what remains is 14 cases. 4 of them are Ukraine versus Russia. There is still one Russia versus Ukraine. Russia is not communicating with the court since March last year, so well, one can quite easily, I think, at least imagine the limited number of options that the European Court of Human Rights has. I have to choose the words, of course, in this respect. And there's cases of Armenia versus Azerbaijan. There's cases of Azerbaijan versus Armenia, Armenia versus Turkey. And there is just as you know, now for something completely different, there is Liechtenstein versus the Czech Republic. Well, quite happily not on a case related to an ongoing armed conflict, but it's a property issue, an old property issue, but still. And this means that the European Court of Human Rights has to operate as an interstate, as an international court for states, like the International Court of Justice, which you know extremely well as you work there. It's a different type of exercise, you know. When you have 70, currently we have about 70,000 pending individual applications. Which normally, I mean, these are individuals, or sometimes the non-governmental bodies, companies or NGOs, you know. And this is the way you approach those cases. The processing of those cases is totally different from how you approach interstate cases. Interstate cases are very rich in terms of facts. So it's voluminous. You have to do lots of things. These are these enormous files. You know, the standard, also to decide on the standard of proof and how to achieve it in a given case. There's tens of thousands pages of applications, you know, and various memorials submitted by parties, third parties. Now the interstate case, the so-called big interstate case, Ukraine and the Netherlands versus Russia, which started as a case about events in the two regions in the east of Ukraine from 2014 to 2015, and then the Dutch application, the application of the Netherlands concerning the downing of the MH17 flight was added, because these are factually the same sort of circumstances, the same location and the same actions, basically. And now it has been joined with the 2022 application of Ukraine concerning the events since the large-scale invasion of February last year. So it's a huge case, and it's also joined by as third parties by, well, I'm really afraid to be mistaken. I think the final figure is something like 26, I might be mistaken, member states of the Council of Europe, and also there is the Geneva Academy for Humanitarian Law as a third party, and so on. So that all those parties, they also make submissions. Well, one would hope that not every state would actually decide to send its separate submission to the European Court of Human Rights, but they would rather coordinate. But that's up to them. Actually, the court cannot force them to coordinate. It would be nice if they do, but you know. So this requires lots of resources for the court. And I don't want to sound like the court, like my colleagues, from the court, from the bureau of the court or the president of the court, who are coming with this to the Committee of Ministers and the Council of Europe says, we are now doing the job of 2 international courts, not 1 international court. So could you please kindly augment the budget, but in reality, this is true. In order to process all these thousands of applications coming from 46, or not from, but against 46 member states of the Council of Europe, and also the residual cases against Russia, which used to be a member, the court has deployed huge human resources. The registry of the court employs about 650 persons. And plus we have 46 judges elected in respect of each member state of the Council of Europe. So it's 700 people. So it's a kind of legal factory, of enormous scope. But you would still need these resources for the European Court of Human Rights. Difference with the ICJs, the International Court of Justice, is that it's much easier to apply to the European Court of Human Rights because you only apply against states who accepted the jurisdiction of the European Court of Human Rights. And you cannot be part of the Council of Europe or party to the European Convention without being a party to the European Convention of Human Rights. And being a party to the European Convention of Human Rights means that you accept the jurisdiction of the European Court of Human Rights. Whereas the jurisdiction of the ICJ, of course, you know better than anyone in this room, I guess, is the most complicated matter. It's just very difficult to go there. You have to be a state, first of all, so no access for individuals. But then that's not enough. You must make sure that the other state actually accepted the jurisdiction of the International Court of Justice. And in most cases, they don't. And when one is wondering why Ukraine has cases at the ICJ against the Russian Federation on the International Convention for the Financing of Terrorism and International Convention on the Elimination of all forms of racial discrimination, this is because these are conventions where Russia accepted jurisdiction when becoming party to the convention, because this is part of the convention system. Same for the Convention for the Prevention and Punishment of the Crime of Genocide. Again, you must accept the court's jurisdiction to be party to that convention. And it's not because, let's say, financing of terrorism is the most important issue there. You cannot, on the most important issue there, you cannot actually go to the European Court, whereas, or to the International Court of Justice. Whereas for the European Court, yes, there is this human dimension. The human dimension is something that, as we discussed, I think, also amongst ourselves, is something that ICJ often lacks, because this is very much an interstate court. But the European Court of Human Rights is Court of Human Rights, so even if we are talking about interstate disputes, the main question in interstate cases in the European Court of Human Rights is to prove the existence of the so-called administrative practice of a state violating human rights. So there's a consistent pattern of behavior of the state which violates human rights. That's why there are more cases, interstate cases in the European Court of Human Rights than interstate cases, at least from our region, at the International Court of Justice. That's quite natural, I would say.
Thank you. Fascinating. Just drawing on this, on armed conflict, but also thinking of migration, and also considering all your work on migration as part of CPT, the Anti-Torture Committee. Here in the UK now, the country is experiencing aggressive anti-migrant rhetoric. The plans to send asylum seekers to Rwanda are underway, and the only thing that seems to be stopping the UK government is the European Court of Human Rights that issued a number of interim measures preventing the UK government to send asylum seekers to Rwanda. With the anti-migrant rhetoric growing, not only in the UK, but beyond, do you see the role of the court increasing in the sphere of protecting migrants and asylum seekers on top of what they're already doing with regard to armed conflict?
Well, migration is certainly one of the main topics for anyone who deals with human rights in Europe. And, as I mentioned, my perspective is, was initially more practical one, because I was just talking to migrants, and I must tell you that's the most emotionally difficult exercise. I mean, it's much easier, believe me. I mean, in my perspective, but I'm sure that would be the case for almost everyone doing this job. It's much easier to enter a cell and in a prison and talk to somebody who killed many people, than to actually speak with a migrant who has never committed any crime whatsoever. He just didn't have the papers that would allow this person to stay where he or she finds themselves now, because they simply wanted better life for their children and for themselves, and or even had to leave their country. You never know. It might well be that they couldn't really stay there. So because they are mightily frustrated. These are people who feel such terrible injustice. They haven't done anything. I mean, they're being treated like criminals, or worse than criminals. So, and that's why, I can give a totally, I hope unexpected dimension. Like, from the point of view of the government, what's easier, to maintain a functioning prison or to maintain a center for administrative detention of migrants? Well, prison is much easier, because all those centers for migrants, you have to repair everything, basically every month or every 2 weeks, because everything gets broken. Because people are frustrated, so they break things. Well, as simple as that. They set their environment on fire. They it's constantly the sight and the smell and everything of mattresses being burnt in those facilities is something that you can never forget, and also how all these installations look, in an almost brand new center just a couple of months after it was populated. Well, let alone places which were not designed for migrants as such, but are converted, old prisons are used to accommodate migrants by some European governments. I'm not talking about the UK here, who are perfectly in a position to provide, if need be, excellent living conditions, but they're sending a message to those migrants that they are not welcome. So they would rather stay in a prison-like environment, not in an open environment. Now, the role for the European Court of Human Rights and also the difficulties that exist. Now I'm entering the field which is a minefield in a way. So I'll try to choose my words carefully. So this is one of the, of course, critical issues between the court and the United Kingdom. And certainly the court has heard loud and clear all these political statements, including threats to leave the European Convention on Human Rights, which in my view would be a disaster. It would be a disaster for the entire system, because the UK is a cornerstone of this whole arrangement. The idea of the Council of Europe Convention and so on, I mean, it belongs to Winston Churchill, It is very much a UK production. It's very much based on the values that have been perpetuated in the United Kingdom for centuries. So it's really that for me it would be a major blow. Not a single authoritarian or semi-authoritarian regime can harm the system that much, especially leaving it or undermining it from inside, than the oldest democracy and the oldest human rights sort of oriented democratic political regime. So can the role of the court is there. The court has actually developed this exact tool, the so-called Rule 39 of the rules of procedure, the interim measures, to address the situation of migrants who face extradition or any other form of return to a country where there's an imminent danger to their most fundamental human rights. It's danger to life, or it's a realistic danger of being tortured there, or well, enslaved, I would say, or anyway being arbitrarily deprived of their liberty. That would be it. So these are not every single human right. There's a long catalog, but really something that is in the very sort of hardcore of human rights, and these are non-derogable rights. These are really key rights. But interim measure is an interim measure. It can never be a solution to the problem. The solution to the problem can only be found by the state itself. And this, it's true that for any politician, it is easier to adopt a discourse which would potentially bring more votes than a discourse that would that can run against some popular understandings or misunderstandings that would require a very sort of painstaking exercises of explaining to people, but also surrounding it by many policies which need to be put in place to have a more sort of humane system. That being said, migration is a challenge. Migration is a challenge. Every society has its capacity. Every society has, it will also be, being very liberal and pro-migration and so on, and completely forgetting about the realities of the world is an absolutely sort of it's a path to nowhere. You will not achieve anything positive here. So there are many problems here, and finding the right balance is something that is extremely challenging. But blaming it on human rights and blaming it on those who actually want the state to maintain its human face, so to say, would be a very wrong idea. So that you must understand your limitations and then form the policies that are viable in a given situation.
Thank you so much. I'll try to be not very greedy and ask the last question, then we'll open up questions in the audience. So we talked about the elephant in the room, Russia, a permanent member of the UN Security Council that started an unprovoked war of conquest, committed numerous war crimes, threatened the world with nuclear weapons. For me, it's difficult not to be disillusioned with international law when such fundamental principles are undermined by the power, the founding power of the UN and the entire contemporary international legal system. Are you still optimistic about international law? We have many students here who would like to pursue a career in international law. What would be your advice to them?
Well, that's really tough, but I'll start again with something obvious. As you might have noticed, I normally speak obvious things, so one obvious thing would be that it is generally counterproductive to be pessimistic. So because being a pessimist means that you are giving up, essentially. And yes, that's a solution, of course. But then what comes next? If I may, I will just again draw from my sort of practical experience. The question that you're asked most frequently by, let's say, by prisoners, talking with them individually, and what will be the result of this conversation? Will actually some things improve? Will something change? Can you make sure that things, really get better? Well, certainly there are people who are so delighted to see somebody, a person from abroad, and interested in their personal affairs, that they would be idealistic and they would assume that everything will change, and then you have to warn them in advance that just do not have very high expectations anyway. But then my answer usually, depending on the circumstances, it was more or less long, but the gist of it was that if you don't do anything, you will not achieve anything. That's it. Again, very obvious. So international law, as I mentioned, it's a project of making this world better. It's true that when it comes to ensuring international peace and security, the system that was set up after the end of the Second World War, which vested 5 major powers, the victors in the Second World War, with extra rights and extra responsibilities for the maintenance of international peace and security, it's obvious that the system has not worked well. I mean, for for Ukrainians, it's easy to say because then you see the all this human tragedy that is unfolding every single day in your country. But then trying to step back and look at how this evolved, you will see that there were clear signs that it was going exactly in that direction. There is nothing surprising, to be honest. I mean, if with hindsight we can say that in what has happened, because the behavior of the majority of permanent members of the Council of the Security Council of the United Nations was far from perfect. It has been far from perfect for so many years. Yes, I mean, a war of aggression in combination with the idea of territorial conquest in Europe, that's something that's completely beyond any limits. But like smaller violations, so to say, I mean, they were taking place, and the system was, I mean, the erosion of the system was there. So it's impossible not to be disappointed with this particular part. However, once there is an understanding that things must change, they will change. It will be too late. As always, it's, international law is usually one war late, when it comes to security issues and when it comes to humanitarian law issues as well. But it will change. But also, international law is a funny system. It is as it was a huge fashion in international law doctrine in recent years. It is a fragmented system. It is. I mean, everyone was writing about fragmentation, for
including me in my PhD thesis. I'm sorry.
Voilà, exactly. Well, I'm also guilty of that, and I know others who did it. Yeah, but it's true that there are certain projects. I would put it not in terms of regimes, but rather in terms of projects. How to make things better. The project of world trade, let's say liberal world trade. The project of protecting environment. The project of migration. The project of whatever, law of the sea, God knows what, and human rights, of course. So, and you can still achieve a lot of progress in some of those projects, but it's true that the foundations are shattered, and they will have to be changed. But that will come with time, I think. So we just have to do whatever we can in each particular role and each particular situation.
Thank you. Now I'll open the floor for questions. Anyone? Let's, if anyone can help with the microphones.
Yeah.
Could we collect 3 questions that we have here, and then we'll answer all of them together?
Mm-hmm. So we start with that. Okay.
Thank you for the talk. My name is Rasha, not like the country, not spelled like the country. My question is about jurisdiction and access to justice for individuals. So we know that the European Court allows people to actually access justice, but that's not the case for people outside the European Union. So if we take the example of Syrian refugees that sought justice against the Bashar regime in French and German courts, same thing for Lebanese people that couldn't seek justice for the Beirut blast in international courts because Lebanon did not sign the optional protocol for the International Covenant for Civil and Political Rights. They did open up several cases in smaller courts. So we had the case against Savar Ltd in the UK. We have several other attempts to open other cases in other courts, but do you think that we're moving towards a more inclusive international justice system? Can we actually get to the point where individuals can access justice on an international court when their local courts fail them?
Thank you very much. Mary, PhD student at IRDR, and I had a question. Apologies if it's a bit simple, but we've spoken a lot about access and individuals having access, but what is the outcome, sort of the impact? So we've spoken about all these cases. What does the court do? How does that impact the individual? Are there sort of sanctions or something to the states? How does that work in that case? Maybe specifically with the UK versus Rwanda. I know that would be a hypothetical, but just a bit more explanation on that, please. Thank you.
I think many of us are aware that conflicts and disasters, deadline is not really clear on the differences. I think my question is mainly on, to what extent would you agree or disagree that victims of disasters fall within the domain of R2P, in that it's a sovereign state's responsibility for assistance from harm?
Thank you.
Right. Well, thank you so much. Excellent questions. All very different, and I'll just take them one by one. I don't think there is any point in trying to regroup them. So I'll start with Rashak's questions. Now it's of course the major premise of international law when it comes to international justice, the courts, that you can only apply to an international court against the state when the state is accepted as jurisdiction. That's very simple. That's why the European system, where basically it's impossible to be a member of the club, sort of civilized European nations, without accepting the jurisdiction, was so good and remains so good. Up until very recently, in the entire European continent, there was only one single state, very well known to us because it's a neighboring to Ukraine state, and it's also people with whom we are very much related in many ways, Belarus, which were not part of this effort. And well, now of course, after Russia was expelled, then also of course Russia is not there. And this is not the case for literally any other region. So it's extremely complicated. And you are right in mentioning that foreign courts can at least be contemplated as an option. And here it depends on the exact subject of your complaint, because if it's about crimes committed in Syria, in Lebanon, let's say, and so on. Then it is quite possible to initiate criminal prosecution of the perpetrators in the states which have incorporated the concept of universal jurisdiction in their law. And in fact, when international criminal justice was being rapidly developed in late 1990s, beginning of 2000s, there were some people who just were imagining a wonderful system whereby, first of all, every state has the primary responsibility for prosecuting most serious crimes against international law. By most serious crimes, I mean the most serious human rights violations, genocide, crimes against humanity, war crimes. And then where they would not be able to do that, there would be other states acting by virtue of universal jurisdiction doing this. And only when nothing of this worked, then the ICC, the International Criminal Court, would be able to deal with the matter. Now, this is more or less what's happening. However, the in reality, universal jurisdiction is a concept which is not fully embraced by many states, and then there's many limitations, and our beloved International Court of Justice reminded states that they are, in terms of classical international law, they have very limited opportunities when it comes to people who enjoy immunities as high officials of their states. In the case the DRC versus Belgium. And then it turns out that the International Criminal Court, which is I would still insist that it is probably one of the best achievements of the civilization. It has been so terribly inefficient. It's just, it's basically doesn't have a record it can be proud of, for over 20 years, which will change. I very much hope so, but, and hopefully is changing now. But, that, so far they have been rather, unsuccessful. So that's why, the more inclusive international justice would only be possible with changes in international law. And now it's more of a combination of domestic and international justice. But, so far I would expect that perhaps the topic of universal jurisdiction will be further revisited and perhaps embraced by more states. Marie has asked about the outcome and the impact of cases. Well, in principle, the function of the European Court of Human Rights is to establish, to answer the question about the existence of the international legal responsibility of a state for compliance or possible non-compliance with its international legal obligations under the European Convention on Human Rights. Well, European Convention on Human Rights as interpreted by the European Court of Human Rights, certainly. Because this court is very much the master of what the convention means. I mean, whether you like it or not, this is how it is. Then the court itself does not deal with the execution of its judgments, except for one case. I will come back to it now. But it's a responsibility that is given by the convention system to a political body within the Council of Europe, the Committee of Ministers. So they have the mechanism for supervising the execution of judgments. And then they discuss problems which arise occasionally, and then they adopt resolutions so that the state could do something. Well, this is more or less that similar to what might exist at the global level. It doesn't manifest itself so clearly, but in fact, when a state does not comply with a judgment of the International Court of Justice, in principle, is the UN Security Council who can push that state in the right direction, but that doesn't actually happen. And well, we currently have a situation when the Russian Federation is clearly not complying with the order of the International Court of Justice on it's not called interim measures, it's called in the ICJ, it's called provisional measures. On provisional measures in the genocide case, because the ICJ clearly told, it was just 1 week into the large-scale invasion, the ICJ told them to stop any armed activities in Ukraine and any armed activities of those groups that they control. So just told them to stop. They're clearly ignoring it. They bluntly refused to comply. And of course, it would not normally be for the Security Council to do something about it, but then we know how Security Council is organized, so it's not a viable option. For the European Court of Human Rights, the vast majority of its judgments are complied with. Rule 39 orders are also almost all of them are complied with, but certainly there are issues there's problems when there's non-compliance, and then ultimately after the adoption of Protocol 14 to the European Convention on Human Rights, now there is a possibility for the Committee of Ministers of the Council of Europe to go back to the European Court of Human Rights under Article 46, Paragraph 4 of the European Convention on Human Rights, and to say that, please rule whether the state has complied or not complied, and he hears the evidence. It has only happened twice so far. One case against Azerbaijan, one case against Turkey. And in both cases, the European Court of Human Rights had to say that indeed the state concerned has not complied with the judgment. But then, so far, no tangible repercussions for that state. Well, Azerbaijan has in effect complied later. So it's the matter is closed because there was one person who was in prison, so he's out of prison. So that's it. Huh? But at that time they didn't comply. So later they did. They hadn't. But for Turkey, it's not yet the case. But then it comes back to the political question on how you exert pressure on that state to actually comply. And because it can end up with the question of whether the state should be expelled from the organization. But this is so traumatic for the organization, incredibly traumatic, that of course this is the measure of the very, very, very last resort. I will not comment on the UK Rwanda. I'm sorry, but further. But that's yeah. But this is the framework. And on the extent, and your question on the conflict of justice and to what extent victims of disasters should be considered as persons who must be protected by states as a matter of legal obligation, I understand.
To what extent does a victim of disasters fall in the domain of the
R2P,
R2P?
I'm not a big fan of R2P. In principle, I think it's a slightly more modern. At that time, it was a more modern tune of the old song. It's not. I mean, it didn't create anything. I think, to be honest. So, in principle, I'm very sort of reserved about R2P. I think there are more important obligations at stake, because I think that states under human rights law, international human rights law, have positive obligations to protect such persons. And these are legal obligations. It's not some resolution or whatever, some general wishes. So I think you can find a way to build a case that this is the obligation stemming, let's say, from the International Covenant on Civil and Political Rights, National Covenant on Economic, Social, Cultural Rights. So you can do that